Yes.
That used to be a thing.
Had to readjust to it now.
Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 24th, 2022. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith, and I am John Neerman. For those of you who are joining us virtually, please keep your microphones muted while you're not speaking. For those who are making presentations, please wait to begin until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular topic, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. And with that, I'd like to thank everyone for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Kendall West Utility LLC for Texas Pollutant Discharge Elimination System Permit number WQ 00157870001. The order of presentation will be applicant, followed by protestants, the ED, and then OPIC. The parties have been notified that they will have 5 minutes collectively, each party, for oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on the application. And I believe that we have Ms. Martin here for the applicant.
Good morning. I'll ask you to check your mic and make sure that there's a little green light on.
There it is.
All right, there you
Okay.
go. The floor is
All right.
yours.
Thank you. Good morning, Chairman, Commissioners. My name is Natasha Martin of the law firm Graves, Doherty, Heron, and Moody, here on behalf of my client, SJWTX, and we're here on behalf of the applicant, Kendall West Utilities. The facts in this case are clear. Following the SB 709 standard, the applicant established the prima facie demonstration that the application met all state and federal requirements, and that proves that it's protective of human health and safety, the environment, and physical property. This burden of proof was met solely by filing the administrative record at SOA, which no one objected to. The standard comes from TCQ's rules as well as the government code. The law does allow protestants the opportunity to rebut this demonstration. Protestants filed evidence which failed to rebut the prima facie demonstration because they failed to apply the correct standards, rules, or policies to the 12 issues referred to SOA. Nonetheless, applicant and ED filed rebuttal evidence from 7 combined witnesses to demonstrate that the application did meet state and federal requirements. All parties participated in the hearing of the merits. After considering the evidence, the ALJ found that the applicant met its burden of proof. The proposal for decision correctly recommends approval of the permit sought by the applicant. The law and regulations for issuing discharge permits in this case were followed by the ED. And the evidence from all sides was considered before reaching this result. There was a lot of evidence to weigh for these 12 issues, but ALJ Pemberton got it right. He said the ED put together a well-done draft permit and met state and federal requirements for the domestic wastewater discharge. In light of this, the applicant chose not to file exceptions to the PFD. The ED and protestants did file exceptions. The ED's exceptions were minor technical changes and changes to, let's say, typos, which the applicant agrees with. The protestants also filed exceptions, but those did not meet the standards for modifying a PFD, and they should not be granted. The Commission's work here today is important. It will allow SJWTX to replace a nearly 40-year-old plant and continue being a regional wastewater provider in Kendall County. This new plant is designed in a way that protects water quality in this state and should be constructed. We ask the TCQ to adopt the proposed order, grant the application, and issue the permit with no changes to the PFD proposed order and draft permit. Chairman, I would like to reserve the rest of my time for rebuttal if needed.
Of course. Thank you, Ms. Martin.
And I believe for the protestants, we have Mr. Dillinger and Mr. Bunch.
And I think Mr. Dillinger may be joining us virtually. Is that the case?
Yes, Chairman Neiman, Commissioners, thank you. I'm Bill Bunch for the protestants. Mr. Dillinger is going to speak first for 1 minute.
Great. Are you there, Mr. Dillinger?
I am. Thank you to the commission. I respectfully request the commission send this application back to staff, to EPA for another MOU review, and then hold another public hearing, because the applicant is bait and switching TCEQ, the EPA, and the public. If you approve this permit without doing that, TCEQ would be putting their stamp of approval on this bait and switching practice. Notice that Ms. Martin said San Jose Water of Texas. This is a bait and switch because it's uncontradicted. There will be a different owner and operator than signed the permit application. It's uncontradicted that there will be a different owner and operator than TCEQ reviewed the compliance history on. It's uncontradicted that there will be a different owner and operator than EPA was told during their MOU review. It's uncontradicted that there will be a different owner and operator than the public was told during the application process. It's uncontradicted that there will be a different owner and operator than the public was told at the public hearings. All of this was raised in the administrative record. Here's what happened. Kendall West applied for the permit as an owner and operator. Despite knowing they would not own or operate the sewage plant or discharge point, they never told TCEQ or the public. Kendall West told various
That's 1 minute.
Mr. Dillinger, I'll just ask you to take a moment to wrap up.
Yes, if TCEQ approves this permit without sending it back to staff, to EPA for another MOU review, and without holding another public hearing, they're putting their stamp of approval on having someone else apply for a permit, go through the public process, and then selling that permit to who will eventually be the true owner and operator. And that's a switcheroo, bait and switching process that TCEQ should not approve and put their stamp of approval on. Thank you.
Thank you, Mr. Dillinger. And Mr. Bunch, the floor is yours.
Thank you, Chair. So protesting parties are downstream landowners, Jay Harpole, Mike Dillinger, Tom Tucker, and Clinton Heather McNew. This is Frederick Creek, a beautiful, crystal clear stream that is a tributary to the Cibolo, and then, of course, the San Antonio River. There's a number of small impoundments that would be the direct receiving waters that we respectfully submit the record shows would in fact be harmed, both in violation of Tier 1 and Tier 2 degradation rules. Our request is that you reject the PFD specifically on these grounds as not based in law, applicable law on Tier 1 anti-degradation and Tier 2 anti-degradation. The record is overwhelming of evidence on these points. And I'd like to highlight that a bit. So your Tier 1, as you should be aware, is a prohibition that only applies to our high-quality waters, highest quality above baseline for swimmable, fishable, which this certainly is. And it says no more than de minimis amount of lowering of water quality is allowed. This rule must be interpreted consistent with the EPA rule on the same subject that says no lowering of water quality. De minimis has to be interpreted to basically mean virtually none. The Black's Law Dictionary is trifling, so trivial as to be worthy of just being ignored. What the PFD says is a discharge to a stream that has no discharge at the moment. It's trifling, it's trivial, it's nothing. To discharge every single day up to 490,000 gallons of treated sewage, that treated sewage having 100 times more phosphorus than the baseline waters, and about 40 times more of the baseline nitrogen, and lowering dissolved oxygen from 6.7 milligrams to liter down to the absolute minimum of 5. There's simply no way in the plain English language or in the law that this can be considered trivial or meaningless. The evidence shows with the ED experts saying that to their knowledge, you have your staff, this commission has never found a violation of the no more than de minimis standard. And I've not heard of a single one. If you know of it, I'd love to hear about it. But what this clearly demonstrates is that this tiny little exception has swallowed the rule in direct violation of the plain language of the rule. And we ask you to stop that because it's having tremendous harm to the streams and the public waters of the state of Texas with nutrient pollution. Nutrient pollution has been recognized for decades as a major harm and threat to our streams, to our Gulf, and to waters both fresh and marine globally. We now have the science, and the science in this record, multiple studies that this agency has funded for the last 2 decades, mostly from Professor Ryan King out of Baylor and other researchers, to look at this exact issue. And those studies show us time and time again that if you go above about 20 to 25 micrograms per liter of phosphorus in these high quality streams, whose baseline is 5 to 8 micrograms per liter, you impair. You don't just degrade more than de minimis. You violate Tier 1 prohibition on impairment because those ecosystems are displaced by more nutrient-tolerant aquatic life. That's what, did she say my time?
She called time. I'll give you a moment to wrap up, Mr. Bunch. That's fine.
I appreciate your consideration. Please put a stop to this misapplication of both the law and science.
Thank you, Mr. Bunch.
The ED next.
Good morning. I'm Stephanie Scogan with the Environmental Law Division. With me today is Gordon Cooper, Jeff Paul, and Gunnar Dubke from the Water Quality Division. Executive Director staff reviewed Kendall West Utilities application for new TPDS permit number WQ 0015787-001 and draft a permit based on that application that will protect human health and the environment. Regarding the 12 issues the Commission referred to SOA, the Executive Director supports Judge Pemberton's conclusions for all 12 issues. The Executive Director recommends that the Commission grant the application and issue the draft permit with the correction provided in the Executive Director's exceptions to the proposal for decision. The Executive Director also reviewed the proposed order submitted by Judge Pemberton. It recommends that the order be amended as discussed in the Executive Director's exceptions and Judge Pemberton's exceptions letter. Thank you, and we're available for any questions.
Thank you. I have none. Colleagues, any questions?
No, thanks.
Okay. OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Pranjal Mehta for the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and the recommended revisions in the ALJ's reply to exception dated June 28, 2022. As stated by OPIC in its closing brief, the record supports findings and conclusions that the proposed permit meets the applicable requirements with regard to the issues referred to herein. OPIC is sympathetic with protestants' concerns regarding anti-degradation review requirements. However, these concerns are better addressed through legislation or rulemaking rather than in contested case hearing proceedings. OPIC agrees with the ALJ's findings and conclusions on all referred issues. Therefore, OPIC recommends that the Commission adopt the ALJ's proposal for decision and the recommendations with the revisions noted by the ALJ's June 28th reply. Thank you, and I'm happy to answer any questions.
Thank you. Colleagues, any questions? Okay, I believe the applicant has reserved, is it 2 minutes for rebuttal?
That's correct.
Okay, Ms. Martin,
minutes.
you have 2 minutes.
Thank you for calling me up so I could finish these notes. Okay. Just two points, Chairman, Commissioners. In response to what Mr. Dillinger, Protestant Dillinger, described regarding the sale of the property to SJWTX somehow being a problem with processing this application. This point was thoroughly addressed at SOA, and the administrative record does include significant amount of briefing. There was a motion to dismiss based on this point, and responses. The ALJ concluded that there was no violation of the notice provided, which was kind of the key issue, that the public was on notice of this application. And so with that, I would suggest that the application can continue because notice was satisfied. In regards to Mr. Bunch's statements regarding anti-degradation, I would put forth that the PFD thoroughly addresses the scientific studies that are being basically presented to you as some sort of law, rule, or policy, and they are not. And so there was no sampling done, there was no testing done of this particular receiving stream to prove that there would be some sort of degradation from nutrients. That's the kind of evidence that you would rely on, not studies that haven't been vetted or adopted by the TCEQ. One such study he mentioned was Dr. King's study out of Baylor. That's not a standard. TCEQ hasn't adopted it as one. They offered the City of Austin WASP study, or model actually, that's also not a standard, and it hasn't been updated. So I would really encourage you not to rely on that. The agency has to follow the IPs. Those are the standards that have been adopted, reviewed by the EPA, and set forth a reasonably achievable limit for nutrients. It's a narrative, it's a narrative standard for excessive nutrients, but that sets forth actual limits for total phosphorus that you are encouraged to rely upon. That's all my rebuttal, unless you have any questions.
Colleagues, any questions?
No? Okay.
Thank you, Ms.
Okay,
Martin.
thank you.
Colleagues, any questions or thoughts for any of the parties before I
No,
share
I
my
don't.
thoughts? All right. I did not find a basis in the record to depart from the ALJ's findings on this matter. Based on the PFD and the record, I believe the applicant has met its burden. As it relates to anti-degradation, the executive director makes an important point, and that is that an increase in a chemical parameter such as total phosphorus is not by itself a demonstration of degradation. We have to connect that to an impairment. And although we know that at some threshold that an impairment will result, I don't see that on this record. I do share OPIC's view and some of the backup material and briefing that the protestants have challenged the current anti-degradation review procedures more than how those procedures have been applied in this case. And while the protestants have not, in my view, presented sufficient rebuttal evidence, they have highlighted and emphasized the importance of reviewing those procedures to ensure that they are keeping pace with the evolving science. And that topic is the subject of an ongoing conversation, as you're well aware, including a stakeholder meeting next week. So, and also I'll add that in my view, it's one of the most important issues that's on our radar, on our docket right now. So those are my thoughts. Commissioner Lindley, how do you see it?
I don't have much to add. I'm in agreement. I thought there was sufficient proof, what was in the record, to satisfy all the statutory and regulatory requirements. So I'm comfortable adopting the PFD with the little tweak that was discussed earlier.
I reached the same conclusion. I'm comfortable moving forward today with the PFD as revised by the ALJ's latest communication to us.
And just to be clear, everybody's using the term PFD, but I think we mean the order.
Oh,
correct?
thank you.
Thank you.
I have a motion unless there's other thoughts or
I think we're ready.
comments. Okay. I would move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated June 28th, 2022, but also modify ordering provision number 1 to indicate that the draft permit is issued, that we approve issuance of the ED's draft permit, and that we adopt the ED's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of whether to affirm, modify, or set aside the Commission's June 29th, 2022 emergency order issued at the request of the City of Ames to compel the City of Liberty to provide continuous and adequate sewer service. The City of Ames is the moving party and should speak first, followed by the City of Liberty. Then any interested persons, currently no one has signed in, the ED, and then OPIC. The 5-minute time period, or each party should have 5 minutes.
Mr. Neslony, good morning.
Good morning. Thank you for having me. Trey Neslony, representing the City of Ames. Ames, of course, supports the order, but as we said in our initial briefing, we requesting one modification. As we stated, there is an area, a significant area within Liberty CCN 20056 that Ames is serving. And now that the contract between Liberty and Ames was what gave us the authority to serve within that area, so there's this kind of gray area where we don't really know if the contract still exists. I know Liberty is now saying, before they said it was going to be terminated, now they're saying it's just suspended. But however you look at that, they're threatening to cut off our wholesale service, so then we won't be able to provide retail service to this area. And this is really Liberty's responsibility, as it's their CCN. We understand that Liberty wants us to provide alternative wholesale provider data, and then also, but if we do that, we have to know how much our demand is going to be. So if they're going to be taking over a significant part of our current service area, then we need to know that. Also, they've wanted to know, what are we going to do to fix the system, which is understandable. And we've told them we've got a considerable amount, as we stated in our briefing, of CARES Act funding, $2 million, ready to be deployed. But if part of our system is going to be obsolete, in other words, they're taking over that area, we don't really want to spend part of that money. We'd rather focus it on the parts of the system we're going to continue to serve. So that's why we're requesting a modification that Liberty state definitively whether they have some kind of plan for taking over this area that's really their, as we see it now, their responsibility as it's in their CCN. And then based on that, we can respond in turn on alternatives and on the other items. So with that, I'll take any questions.
Thank you, Mr. Neslony. I have none. Colleagues, any questions?
No, thank you.
Okay, thank you, sir. Next up, we'll hear from Mr. Vassar, I believe, for the respondent. Good morning.
Good morning. Good morning, Commissioners, General Counsel, ED, and OPIC. City of Liberty wants a fix. They want a permanent fix. They don't want to kick the can down the road. We don't want a Band-Aid. It's our TPDS permit. We're obligated to comply with it. We were here 2 months ago, and there's been substantial briefing since that time, which I know it's been reviewed, and Mr. Neslony addressed some of the issues. What Liberty is asking for is that the order address accountability. Accountability to fix the system so that we're not back before you again at the end of 120 days asking for another extension. Commissioners, it's not required in the order to address some of the around the edges issues that really are better subject for litigation, which is ongoing. You don't need to talk about rates or look at CCN issues. Yes, Liberty has consented to Ames serving an area within Liberty CCN. We see the contract as valid and ongoing, but again, we want accountability. And so what we're asking commissioners is that the order be modified ever so slightly to require that we see options in writing, not just a pump and haul service that was referenced, that was not attached to the reply brief the other week, but what are other options that are available? Could include fixing the system, what those specifics would look like. Could be package plans. We don't know. It's their collection system at this point. We're open and amenable and even encourage opportunity to engage with TCEQ staff on this issue. That may drive a solution. Again, what we're looking for is not just ultimately putting this down the road for later resolution. If there are questions on the CCN issue, we're happy to address them. Frankly, we think they're built upon several what-ifs. Well, what if the contract is not valid? What if then Ames decides to cut off these 60 or so, we understand, connections within its collection system. So, Commissioners, we appreciate the consideration of our modification request. If there are any questions, we'll certainly address them.
Thank you, Mr. Vassar. Colleagues, any questions?
No, thank you.
I have no questions.
Thank you.
Thank you.
And we don't have anybody signed in to speak on this?
That's correct.
Okay. Let's hear next from the Executive Director.
Good morning. Excuse me. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Benjamin Worms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Harrison Malley of the Environmental Law Division and Frojvoer of the Water Quality Division. The issue today is whether the Commission should affirm, modify, or set aside the June 29th emergency order requiring Liberty to provide Ames continuous and adequate sewer service for 120 days. The TCEQ's jurisdiction in this matter is limited to environmental protection and public safety. Since the issuance of the emergency order, both parties have provided additional briefing on the matter. The Executive Director cannot weigh in on the contract or the CCN issues raised by the parties, as both fall outside of the jurisdiction and expertise of the agency staff. Furthermore, there's very little in the briefings beyond mere allegations for the ED to evaluate and consider. At this point, it's even unclear whether Liberty intends to accept flows from Ames past the expiration date of this emergency order. Based on the record, the ED does agree that Ames does not have any short-term options to provide alternate service should Liberty cease accepting wastewater flows from Ames. The ED's staff has not been able to identify an alternate wastewater treatment option that could be completed in less than approximately 1 year. Given the limited information that is on the record and the few available options, the ED recommends modifying the order to require both parties to attend alternative dispute resolution proceedings in an effort to settle this matter. Thank you, and we are available for any questions you may have.
Thank you, Mr. Worms. I have none. Colleagues, any questions for Mr. Worms?
No, thank you.
All right, let's hear from the Office of Public Interest Counsel.
Good morning. OPIC recommends the Commission affirm the June 29th emergency order without the modifications requested by the parties. We are in agreement with the Executive Director on this. I believe we concluded the modifications requested by Ames would require the Commission to look into issues of contract interpretation and CCN requirements and stray a little too far afield from environmental protection. We support the general idea behind Liberty's request to encourage Ames to seek alternative long-term solutions, but the requested modifications seemed too vague to be enforceable, and our understanding is any potential alternatives would probably require more time to implement than we have under the emergency order timelines. So for those reasons, OPIC recommends affirming the emergency order but denying the requested modifications.
Thank you, Mr. McWhorter. Colleagues, here's how
We have, the city of Ames has 3
Oh,
minutes
Mr.
of
Nesloni,
rebuttal.
I was cutting into your rebuttal time. If you have any rebuttal comments to offer, we're happy to hear them.
I would just say that we support ADR in the matter, what the staff suggested, and we're happy to give some of the information that Liberty wants if we know what our service area is going to be. That's kind of what I'll say in closing.
All right, thank you for that. I guess I should ask Mr. Vassar what his position is on ADR.
Commissioners, we are not opposed to ADR. Our position has been that we don't want it to be a waste of time. And so if we move into ADR and we have a day of mediation, we would like to see some advanced detail about what some of the fixes are. Mr. Nesloni referenced CARES Act funding. So to the extent that we end up in that posture, we would like to be able to see some of that detail, because this is a very highly technical issue or dispute, and so the more information we can go into ADR with, the better.
Thank you, sir. My view is this, colleagues, our order is about protecting the environment. I think the cities are inviting us into a dispute over a contract and CCN issues. I think those disputes belong in court or before the PUC. The notion of, I'm all for mediation and alternative dispute resolution, but in this case, I think since the controversy, in my view, is largely outside our jurisdiction, more about contract and CCN, I have some hesitation in having this agency sponsor or refer that. I'm also concerned, I think OPIC points out, makes a very good point in identifying the calendar and the timeline as a potentially frustrating issue too. So I don't have, well, let me say this. I would propose that we affirm the order without the modifications suggested by the parties. And I don't feel strongly about the ADR referral, but I think I would be more inclined to not include that.
I'm in agreement. I always like the idea of ADR, but I'm not sure in this specific situation it's quite appropriate. So I thought what Vic stated and how it was stated was very well said, so I don't have anything to add.
I could not agree more. I think the requested modifications both direct the question really closer into the PUC's authority. The issues dealing with respective CCN service or contractual matters are outside of our scope, and I think your points are very well taken about how even suggesting that ADR might be productive seems like a potential misspent state resources where our venue and our expertise really point to environmental impacts. And I think this is a little outside of that, and I'd be in agreement with affirming the order as is.
I think we're ready for a motion.
I move that we affirm the Commission's June 29, 2022 emergency order.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the annual review of financial assurance mechanisms and cost estimates for radioactive material license number R04100, held by Waste Control Specialists, LLC. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel, and members of the public. On behalf of the Executive Director, I'm Vaishali Tendolkar with the Radioactive Materials Division. With me is Chance Goodin with the Radioactive Materials Division, Amy Robinson with the Environmental Law Division, and Mark Stobner with the Financial Administration Division. In compliance with 30 Texas Administrative Code Section 336.736C, Waste Control Specialists' financial assurance mechanisms and cost estimates are reviewed annually by the Commission at an open meeting to ensure that sufficient funds are available for completion of the low-level radioactive waste disposal site closure plan. Included in your backup materials is the radioactive materials license financial assurance summary for the waste control specialist for your review and approval. Thank you for your consideration, and we are here to answer any questions you may have.
Thank you. I have none. Colleagues, any questions for Ms. Tendolkar?
No questions.
None. Thank you.
All right, Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
Mr. McWhorter.
OPIC appreciates the ED's review of these financial assurance mechanisms and cost estimates. I have no questions or concerns. Thanks.
Thank you. Colleagues, this appears to be appropriate. I think it's consistent with our rules. I'm ready to move forward with it.
I agree. I move that we approve Waste Control Specialist financial assurance mechanisms and cost estimates as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the Office of the Public Interest Counsel's 2022 annual report.
Mr. McWhorter.
Good morning again. Commissioners, as you know, Texas Water Code Section 5.2725 directs OPIC to report to you annually concerning OPIC's performance, our budget needs, and recommendations we have for statutory or regulatory changes. The written report submitted in your backup materials is intended to satisfy that requirement. At pages 3 through 7, the report lays out OPIC's performance measures previously adopted by the Commission and also lays out fiscal year 2022 information related to the 4 types of matters we are required to measure, which are environmental matters, district matters, rulemaking, and enforcement. At pages 7 through 9, there's discussion of OPIC's budget and issues related to contracting for outside technical expertise. Finally, at pages 10 through 23, we discuss legislative change recommendations that would allow expanded and more meaningful opportunities for the public to participate in hearings for concrete batch plant standard permit registrations and require updated protectiveness reviews of the standard permit for concrete batch plants every 10 years. Thank you for the opportunity to report about OPIC's work, and I welcome any questions or feedback you may have.
Thank you, Mr. McWhorter. Well, colleagues, the reported performance metrics and budget are pretty steady state year over year, so I have no concerns there. There are no recommended rule changes. As Mr. McWhorter pointed out, there are several legislative recommendations pertaining to concrete batch plants, and without getting too much into the weeds at that, I would say that any substantive changes, of course, need to be grounded in the science. And procedurally, and we may have discussed this before, probably in this setting, there is a potential deficiency that could prejudice the rights of a neighbor who is beyond 440 yards at the time of permit issuance, but later finds himself within that distance if the permittee decides later to move the location of an emission point. And I want to emphasize the word potential because I'm not aware of any case where this has actually happened following the denial of a hearing request. Nevertheless, I understand that Executive Director staff is looking at addressing this issue through a rulemaking. So those are my reactions and comments. I appreciate the report. Commissioner Lindley.
I don't really have anything to say. I appreciate the report as well. I thought, as usual, it's very thoughtful. And, I think a lot of the things that y'all reference in the report are going to come up in the legislative session, would be my guess. And so, I'll just leave it at that. I think we're not done discussing a lot of the issues raised. So, but today, I don't see a need to necessarily take any action on them.
I appreciate those comments. I think I'm in agreement, and I appreciate your context on the one particular item in the legislative proposal that I was also under the impression that the executive director is taking a look at that, and I'm eager to see what that path forward might look like and how that might impact and require a course correction or adjustment on these legislative recommendations. But I'm happy to have them move forward to be reviewed by the legislature, and also I would love to see if this legislative recommendation is proposed and considered or commented upon by executive director staff in our agency's course of considering all legislative recommendations. I think that would be very appropriate. I had a question for you, Mr. McWhorter, about the performance measures, and I think OPIC has done a wonderful job, and anytime that the year after year metrics are 100%, we're doing it all, I think that's always worth a pat on the back. But I want to ask because we haven't yet seen the hypothetical, where in your opinion, if caseloads really increase and workload on the fine attorneys in OPIC really starts to spill out over the edges, of those 4 areas that OPIC tracks and seeks to respond to covering that, where do you think our agency might want to look closest and see where would OPIC start to say that we're doing 100% here, but maybe this is qualitatively that level of work is starting to suffer. I'm not sure that we would expect to see a less than 100% number first, or what should we look for not to get ahead of ourselves, I want to take advantage of your experience and expertise while it's here in front of our dais. So, love your comments.
If I'm understanding the question correctly, I mean, I think we'd probably continue to participate in all four of those areas, but probably take a deeper dive into which ones, there are other factors in that Chapter 80 rule that we have adopted by rule, and we might have to start applying those a little more strictly, and look at matters where all parties are represented or where the issues may be smaller in scope, and just start, prioritizing cases a little differently, I would say.
I really appreciate that. In my view, I would hope that our commission were able to look far enough ahead, raise the flag, ensure that an adequate number of resources were available so that we could continue to cover everything. But I think that's a useful piece of context, and I appreciate that. Thank you. I don't have any other comments.
So no action is necessary on this item. So, Mr. McWhorter, thank you for the report. We appreciate it. And Ms. Smith, I'll ask you to please call the next item.
Item 5 is consideration for approval of the Chief Auditor's Office Annual Risk Assessment and Fiscal Year 2023 Audit Plan, and the Chief Auditor is here to present.
Good morning, Mr. Hardison.
Good morning, Chairman. Good morning, Commissioner Janeka, Commissioner Lindley, Public Interest Counsel, and General Counsel. For the record, my name is Mike Hardison. I'm the Chief Auditor of the TCEQ. With me is Jim Walker, my Deputy Chief. We're before you today to present and request approval of our Annual Risk Assessment and Fiscal 2023 Audit Plan. Chapter 2102 of the Texas Government Code requires that the Chief Auditor prepare a risk-based audit plan annually and that plan be approved by the Governing Board. As described in our report, we developed our audit plan after interviews with TCEQ management and staff, as well as evaluation of prior audits, financial records, and legislative initiatives tasked to the agency. Our report outlines our risk assessment process, as well as the proposed audit projects for the coming fiscal year. At this time, I'd request approval of the fiscal year 2023 audit plan, and I'm available for any questions you may have.
Thank you, Mr. Hardison. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka?
No questions other than to say I'm really pleased by the complexity of that process in generating this look forward. So thank you for that work.
And has anyone signed in to speak?
No one has signed in.
Mr. McWhorter, do you have an opinion?
I have no questions. I support the plan presented by Mr. Hardison and his team.
Thank you. Colleagues, I've reviewed the risk assessment and audit plan. Mr. Hardison and I have had some conversations about it. I'm comfortable with it and ready to move forward.
In light of that, I'll make the motion that we approve the fiscal year 2023 annual risk assessment and audit plan as recommended by the Chief Auditor.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
I'll say aye too. The motion carries. Thank you, sir. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Chapter 575 of the Texas Government Code. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. I have none. Any questions?
No?
No questions. I just have to observe that on 2 of those trips, reimbursed travel items, I've gotten to attend exactly similar functions on previous occasions, the annual conference or that sort of a federal entity supported travel, and I think these are really worthwhile things that really help our staff continue to engage and work far beyond where our out-of-state travel budget may allow to send them. So I'm really pleased with these. these actions from the outside world. Thank you.
Since you brought it up, I'll pile on real quick. I know there was a conference that sponsored a TCEQ booth that allowed us to get out and help educate the regulated community. So definitely big thanks to the people who are helping us do our work. Ms. Smith, has anybody signed in to speak on this item?
No one signed in.
Mr. McWhorter.
OPIC recommends approval of the resolution acknowledging receipt of gifts and donations as presented by the Executive Director.
Colleagues, I agree with that. I'm ready for a motion.
I've got one. I move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated August 5th, 2022, docket number 2022-0794-MIS.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Thank you, Ms. Tran. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, items 7 through 19. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before your items 7 through 19, the total assessed administrative penalties are $157,813, with $31,343 deferred, $20,309 applied towards supplemental environmental projects, and $106,161 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No?
Not at this time.
Ms. Smith, has anyone signed in to speak?
We have, on items 7, 8, and 12, we have a number of individuals who signed in and indicated that they would be available for questions. And on 7, we had someone signed in, but they're to participate virtually, but they don't appear to be on the line.
Okay. Maybe we'll come back to that person after we hear from OPIC.
Good morning. The one order that I had a little bit of concern about was Order 7 and the penalty calculation. And I have no qualms. The ED, as usual, did a great job going through the calculations of the penalty policy matrix and the harm and the release and all of that. But in looking at the facts underlying that incident, and I know the amount of VOCs released during that incident were under the 100-ton threshold, but given that they were within 3 hours and the impact on the neighborhood with the shelter-in-place orders and things of that nature, I'm sort of still thinking about that one. But everything else I'm on board with, and I can't get on board with number 7, but I would just offer that I think if there was ever an incident when one might want to look at adjusting the penalty upward for factors as justice may require, that this would be a suitable candidate for that consideration. But with that said, I can support all the orders.
Thank you, Mr. McWhorter, and I know we received comments to that effect as well as part of the backup material. Let's try again for anybody in the room or online who would wish to comment on item number 7. And just to be clear, is our line unmuted so they would be able to speak if they're joining us remotely? I'm seeing an affirmative nod. And I'm not seeing or hearing any interested persons. Colleagues, I appreciate Mr. McWhorter's comments on item number 7. It's something I'm sensitive to. I understand and get the comments. It is a rare thing for us to depart from the penalty policy. There seems to be no question here that the penalty policy was carefully followed, and I think the few instances that we have done that I can recall, they've been, true extreme hardship cases where we have, I guess through mercy, for lack of a better word, adjusted the penalty downward. The reason I'm reluctant to depart from the penalty policy is that we are then unbounded, and how do you select the right number? So I'm sensitive to the comments. I think, on balance, I would prefer that we not depart from our penalty policy in this case.
I completely agree.
I think I'm in agreement on this matter. I did have a question to direct back to Mr. McWhorter, if I could, and that's to try to understand the nature of the distinction here. And I think what I'm gleaning is that the total emissions really clearly fell under our agency's line, distinguishing between minor and major sources, and therefore this item has been appropriately calculated. However, OPIC is aware and sensitive to the public perspective or reaction to the fact that this, though it was a minor source, the volume within the short time duration, or large volume over a very short time duration, really, in the public's eye for that day, for that short period of time, it was perhaps releasing more commensurate with what would be categorized as a major source by our agency, or typically categorized as a major source, where that was a disproportionately high release in a short amount of time for a minor source, I think is what I'm trying to make sure is the technical distinction that seems to be the point of disconnect in the public's happiness here.
Yes, and for context, it was the result of a fire. I don't know if you've seen the other information about it, but so it was within I believe a 2 or 3 hour time period, a very concentrated amount of smoke and matters escaping, and the issuance of the shelter-in-place order for the neighbors, I think, for approximately 3 hours. And I mean, just to add a little more, I mean, also I think and I know that the compliance history is calculated in accordance with all applicable formulas. They got a 10% discount for being a high performer, and I think that that was a little unsettling, I think, for some of the people. And also just the fact that, rather than the 25% or the $25,000 per day that would happen for the major source categorization, they started out at the 10,000 mark, maybe,
Approximately.
Or I guess it's more like 12,500.
Correct. Yeah, the 50% mark. I sincerely appreciate that. I think that helps confirm what my impression of this situation is, and I don't think that I don't think I would be unhappy if the executive director staff gave some thought to how we might try to account for future occurrences like this, and certainly where sheltering in place or impacts on the public outside of the facility occurred. I think that's a very strong factor, but one that we need to make sure we're being consistent on. So I appreciate the extra thought and context on this. I don't have any other suggestions or comments.
Are we ready for a motion?
We are, and I can make it, unless it's, I move that we adopt items 7 through 19 as recommended today by the executive director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 20 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2022 through June. There were 850 effective administrative orders issued, and of those, 119 contain supplemental environmental projects. These orders assessed a total of $11,065,793 in penalties, with a payable amount of $6,661,046. $2,563,807 are to be paid towards supplemental environmental projects. 12,378 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,631 enforcement action referrals have been received. There are 1,948 pending administrative orders with 516 cases that are on the backlog. 204 cases are pending at the Attorney General's Office for representation in district court, and 13 judgments have been issued. 1,933 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2020, 2021, and 2022. We are available to answer any questions you have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No, thank you.
None.
Has anybody signed in to speak?
No.
Mr. McWhirter?
No questions. Appreciate the report.
And colleagues, there's no action necessary on this report, so thank you for the report. That takes us to the next item, which was not properly noticed. I'm just going to insert it here. August is retirement season, and golly, I hate bringing this up, number one, because I don't like to think about it, but number two, it's at the risk of leaving people out, and I know I'm doing that, so apologies. But I want to begin with Tanya Baer. Thank you for your, compared to some of the folks around here, you had a relatively short tenure, but it's been an impactful tenure. And I know state employees are always asked to do more with less, and for especially the air permits division, you know, the economy is strong, Texas is growing, so you've been asked to consider more permit applications and do that with less time. And so I really appreciate the work that you've done to taking a scalpel to the calendar and carving hours and days out of the permitting timelines. It's made a big difference, and that is just one of the things that I appreciate about your service, Tanya. And let me pause there and invite my colleagues to share some thoughts.
Sure. I think we're supposed to call her Tanya Miller now. Yes.
Oh, I am sorry. I am not current on the
She's had a
gossip.
big month.
Yeah.
She's announced her retirement. She's gotten married, and she's taken a kid to
Congratulations.
college. So I joke there's only one more thing you can top that with, but I think that's out of the realm of possibility. Yeah, that'd be having a child. You know, I will just add, everything you said's completely accurate. I love to recognize people, but I also feel bad afterwards because I know we will, you know, inadvertently leave someone out of the list of people we should recognize. But Tanya does deserve some recognition for what she's done for the agency, and more than just the Office of Air, right? She worked here a different time, years ago, in our radioactive waste division and IGR. She's done a lot for this agency. And so, yeah, big shoes to fill, but good luck in your next adventure.
I felt Ms. Miller's departure from our agency the first time most acutely and most directly. I was in the radioactive materials division when she left. She departed us for greener pastures to go lead the Office of Public Utility Counsel, and I think did a wonderful job there. We put a little piece of paper up on her office lamenting her departure. It was Ain't No Sunshine When She's Gone. That was the song that came to mind, and I just find that too perfectly fitting as we see and watch where she's headed, and I wish her luck on those adventures up ahead. But thank you so much. You left this agency much better than you found it. We appreciate it.
Thank you, Tanya. Next up, Vic. Vic, I can't imagine an agenda without you sitting right there and getting your wise counsel. I've really enjoyed working with you, and let me speak to the quality of the work. I have relied heavily on the work of you and your team. I'm actually not sure exactly who's doing it, but you know, you're at the top of that organization, the top of that team, so I'll give you credit for it. I have relied on it, and I've been able to rely on it repeatedly and in the highest confidence because you brought excellence to the task. So you will be missed. I may have an additional thought, but let me hand it off to my colleagues.
Yeah, again, big shoes to fill. You know, the best thing about Vic is just how nice he is. I mean, counsel is outstanding, but also just a really nice guy. And there's a couple people when I first started the agency that were very helpful to me and were very kind to me, and Vic would be one of those. My cube was next to his office, and I would just pop down there and ask him a question about, I just told a member of the public this, and I don't know if that was right, and he was kind enough to counsel me or help me get questions answered if, you know, the public had a question that I couldn't answer, which was usually the case. And then somehow we would get off topic, which has happened a time or two with me, and we talk about tennis and our love for different tennis players and all these other wonderful little snippets of conversation. We haven't had one of those in a long time, but I do remember them, and yeah, it's going to be really weird not having you up here, but very excited for you, very happy for you, and glad we get to take a minute to recognize you.
Thank you so much, Vic, for giving a voice to a really critical perspective and view, and one that I think taps into and gives inspiration and really helps provide motivation to a lot of our employees and staff, where seeing that additional piece of the context, the very difficult contextual puzzles we have to weigh in on and try to be consistent, fair, buttressed by science. I think that you have really helped create that voice, and it's been powerful both to the public but also back towards the agency and helping us try to be better. And I think it leaves really big shoes to fill. I'm very eager to see where your great work continues to grow with the very, very good team you're leaving behind with our agency. So thank you for all of that. And there's a lot of fights and battles and things that didn't come up to the forefront or the notice of the public, but thank you again. We really appreciate it.
I have an assignment and a memento. The assignment is, since this was not noticed, I'd like briefing on whether this action is void or voidable, because I can't recall.
I'm going to call it ceremonial and say it didn't need to be noticed at all.
Okay. Ceremonial. The memento will have, thank you, Bobby. Let me read it. We have a flag flown over the Capitol and a certificate to go with it from the Senate of the state of Texas, and it reads, "This certifies that the Texas flag herewith was flown in honor of Joseph Victor McWhirter in grateful appreciation for 29 years of dedicated service to the state of Texas," and it's issued by Texas State Senator Sarah Eckhart, August 17th, 2022. Colleagues, should we allow Mr. McWhirter to turn his microphone on or not?
That's a good question.
Should we vote on that? Take a ceremonial vote?
I'm
Nick, you don't have to say
fine letting
anything,
him
but
speak. Yes.
if you'd like to say something, I feel like that's only fair.
Well, I just really, the only thing I can think to say too much is thank you. I'm very touched, and that means a lot to me. And it's been a pleasure to work with all of you. I appreciate the respect and courtesy and consideration you've always shown, both to me personally and to my office, to the Office of Public Interest Counsel, and I just really thank you.
Thank you, Vic. All right, with that, I think we're ready
Our executive director has his hand raised.
Toby.
No,
please.
Toby Baker, Executive Director of the agency. Chairman, I'd be remiss to, I hate to give you bad news at agenda, but since she's here today, and this is going to be her last agenda, but you guys don't know this yet, Susan Jablonski is going to be leaving the agency at the end of this month.
Nope. Cut him off. Turn the mic off.
It has been under wraps, and I was actually working on her just this week to try to change her mind. Apparently, I'm not as persuasive as I think that I am. So I just want to make sure that you know that she will be. She has done a great job in the enforcement division, and but I think that you would like to know that. And then also just Jonathan Walling, who's been by my side for a number of emergency response events over the years. Make sure that y'all are aware that he is going to, as he, I think, mine rocks. But you can ask him all about it. Anyway, just I had to mention both those names to make sure that y'all were aware, because Susan's here today, and I wanted to just make sure that you know that we appreciate all the work that you've done for us over the years. Thank you very much.
Thank you, Toby.
Sorry for the late.
Yeah,
don't
thank
sorry
him.
for the late.
For the news.
News on that one.
They're like little cuts. They
hurt.
They hurt. Jonathan's been wonderful. He'll, his presence will be missed deeply, as will yours, Susan. We really appreciate your leadership. You've been a great leader in this agency. And Toby, don't bring us this kind of news.
No, I'm like,
Emily?
yeah, I feel like there's probably a lot I could say. Had the pleasure of knowing both those folks, but probably Susan the longest out of those two. I don't even know when we probably would have first met years ago. And she's just solid, right? I mean, Susan is a person I've always said I want on my team because she's such a hard worker. And she's just wicked smart. And I've always respected that about you. So, man, not a good Wednesday, but very happy for both of you. Jonathan, if you're listening as well, going to be missed, but I hope whatever you do next is something you're really, really looking forward to. So best of luck out there.
Bobby?
I can't think of any words that can possibly hide the amount of upset feelings I have right now at this surprise. I'm really struck by the huge loss of talent and institutional knowledge it's going to mean for our agency, but I think that's a great thing for whoever is getting your help next, and that goes just as strongly for Mr. Walling. I look forward to seeing how y'all continue the work that I'm sure every former TCQ employee keeps in the back of their mind, where and how can we continue to voice and look out for the state and its people and environment. So thank you for all of your good work, and look forward to continuing to watch what you do for us.
To end on an upbeat, maybe, the silver lining is that we have a very deep bench, and so it gives us an opportunity to allow other leaders to move up, and so at least we have that going for us. All right, Ms. Smith, I think we're ready for the next items.
Items 21 through 24 are for closed session, and the commission will meet in closed session in Building E, Room 211S at, I want to say 5 or 10 minutes?
5.
In 5 minutes. Would be about 10:42 approximately, as permitted by the Open Meetings Act, including Texas Government Code Sections 551071 and 551074, to take up and consider matters pursuant to the items number 21 through 24 as posted and noticed.
The time is 10:37. We are in recess.
The commission met in room 42, in Building E, room 211S for closed session from 10:44 until 11:28 a.m. on item numbers 22 and 23, as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned, and the time is 11:33.